of our nation. It is a moment for us to come together today, not just as legal experts, policymakers, or advocates, but as citizens who share a deep love for our country. Not just as legal experts. It's a time for policymakers or advocates, critical analysis, and above all, a shared commitment to a vision for our Philippines that upholds the dignity of every Filipino and fosters peace and above all, where justice and freedom and prosperity for our Philippines. As we proceed with this debate, let us approach each argument with an open mind and perspective with respect and openness, guided by the enduring principles that unite us. Let us remember that ultimately, our goal is to ensure that our Constitution reflects the best of what we aspire as a nation. It's about crafting a living promise to future generations that we will leave them a society that is fair, just, and filled with opportunity for all. As we navigate through this debate, may we all contribute constructively and thoughtfully to this pivotal moment in our nation's history. Before we begin, I would like to announce our moderator for today, Attorney Eugene Cao. He is a professorial lecturer at the Ateneo de Manila University School of Law. When he teaches Constitutional Law 1, Administrative Law and Public Officers, Election Law, Local Government Law, and Obligations and Contracts. He is a 3-time recipient of the Raimundo R. Dizon Professorial Chair in Political Law from 2021 to 2024, and the recipient of the Nippon Foundation Professorial Chair for academic year 2023 and 2024. He was also a recipient of the Tan Yan Key Foundation Professorial Chair in 2021. Ladies and gentlemen, I would like to introduce again Attorney Eugene Cao.
Thank you very much, Mr. Angeles. Good morning to everyone. Welcome to the debate of the day. We're very excited to have legal luminaries with us, Justice retired Senior Associate Justice Antonio Carpio and Professor, our very own Tony Abante. We have a very meaningful discussion ahead of us, and we are very much honored to be in the presence of our legal luminaries. So for today's debate, we will be giving each speaker 15 minutes of uninterrupted presentation. And then thereafter, after each speaker, will be given another 10 minutes for the rebuttal. So to get the debate started, we would now like to introduce the speakers. This first speaker needs no introduction, actually, but we all know him. Justice Antonio T. Carpio, he obtained his law degree from the College of Law of the University of the Philippines, where he graduated valedictorian and cum laude. In 2001, at the age of 52, he was one of the youngest appointees as an Associate Justice of the Supreme Court. To date, he has spent 836 full-blown decisions, leaving no backlog in his docket, a feat rarely attained by a Supreme Court magistrate. So let us all give a big warm round of applause to our Justice Antonio Carpio, the defender of our territory and defender of our sovereignty.
Thank you for that kind introduction. A pleasant morning to everyone. Thank you for inviting me to discuss with you People's Initiative and the amendments to the Constitution. I am against the People's Initiative because it is unconstitutional. I'm referring to the present People's Initiative. Why? One, the Constitution says that Congress shall provide for the implementation of the People's Initiative, and Congress did pass Republic Act 7535, but in Santiago versus Comelec, the Supreme Court said Republic Act 7535 is incomplete, inadequate, insufficient to implement the People's Initiative. In effect, the Supreme Court struck down Republic Act 6735. And so there is no enabling law up to now. Congress has not passed any remedial enabling law, and therefore the people's initiative cannot be implemented. And that's the reason why the COMELEC recently suspended its rules to implement the people's initiative, because they realized there is no enabling law. Congress must first pass an enabling law. Second, uh, in uh, in Lambino versus COMELEC, which I penned, the decision there did not resurrect, did not revive Republic Act 6735. In the body of the decision, I wrote, that's the majority decision, we are not revisiting Santiago versus COMELEC because we don't have to revisit Santiago versus COMELEC to decide the issues before the court in Lambino. So we did not revisit Lambino. And if you look at the folio of Lambino, it says the petition is hereby dismissed. So we are taught, of course, you all know that it's the folio that is the ruling of the Supreme Court. And the ruling says the petitions are dismissed. If there is a conflict between the body of the decision and the folio will prevail, of course. But there is no conflict in Lambino between the folio and the body of decision. But in Lambino, in the MR, the court resolved the MR by saying, we affirm with finality the decision. There was no reversal of the decision in Santiago, but the Supreme Court stated a fact that 10 justices believe that Republic Act 6735 is valid. Now, so we have a situation where the folio says the petitions are dismissed, and in the concurring and dissenting opinion, 10 justices said that they believe that the Republic Act 6735 is valid. So there is a difference, there is a conflict between the folio and the opinions of 10 justices, which will prevail. Well, if what will prevail, if there is a conflict between the folio and the body of the decision, the main decision, if the folio will prevail, that's the ruling, then it will prevail even more if the conflict is with the dissenting and concurring opinions. So very clear, there is nothing there in the Lambino versus COMELEC which says we are reversing our decision in Santiago. Third, there is the problem of the Lambino case was decided about 9 years after Santiago. So for 9 years, the Santiago decision has been final already. Can the Supreme Court revive Republic Act 6735, which 9 years before had already been declared as not existing? It does not form part of the legal statutes, statutory law, because when the Supreme Court said it's inadequate, incomplete, insufficient, then it practically said it's void. No, the Supreme Court cannot revive, because to revive it, it requires legislative power. And the Supreme Court does not have legislative power. So the Supreme Court cannot really revive a law that has been declared non-existent for the last 9 years. And there is another thing. We have what we call the doctrine of immutability of judgments. Now, let me quote a recent decision by Chief Justice Esmundo in Republic versus Heirs of Gotinco. He said, it is well established, it is a well-established rule that a judgment, once it has attained finality, can never be altered, amended, or modified, even if the alteration, amendment, or modification is to correct an erroneous judgment. This is the principle of immutability of judgments, to put an end to what would be an endless litigation. There are exceptions, of course, to correct clerical errors. There's none here. And what they call the non-pro-tonc entries, which means that a later decision can supply an omission in a prior decision, but never to correct, to reverse a judgment, just to supply an omission that was made inadvertently or by mistake, but never to reverse a decision. And also there's the exception is a void judgment. Well, the Supreme Court will never declare its own decision as void. The Supreme Court declares decision of lower courts as void, but it will never declare its decision as void. And lastly, you have the exception that when there are circumstances that transpire after the finality of the Supreme Court decision, like for example, if a criminal law is repealed, persons who have been convicted serving judgment will have to be released because that is a circumstance that happened, that transpired after the finality. So, in other words, under the doctrine of finality, of immutability of judgment, even if the decision of the court is wrong, once it has become final, it is immutable. The court said, if it cannot even correct an erroneous judgment. So there is a saying, the Supreme Court is supreme not because it is infallible, but because its decision is final. Why is that? What's the rationale behind that? Well, if the Supreme Court says that your contract is null and void, that's between you, that's the law between you, that's a contract, the Supreme Court cannot say 50 years later, your contract is valid, because transactions could have transpired in the course of 50 years, and that will destabilize the legal system. That there is no stability anymore in contracts. So that's why once it has become final, even if it's erroneous, it cannot be undone anymore, because you need stability in the legal system. And that's why when the Supreme Court says this law is unconstitutional, it has become final, that's it. It cannot be revived by the Supreme Court anymore. Only Congress can revive it. And Congress up to now has not filed an enabling law, has not approved any enabling law to implement the People's Initiative. So there you are. I'm against the present People's Initiative because there is no enabling law. And even COMELEC says we have to suspend. They realize that there is no enabling law. Now, I'm also against the present People's Initiative because they are saying that our purpose is to change the economic provisions of the Constitution. But if you look at their proposal, there's nothing there about changing the economic provisions. They are proposing to change that provision of the Constitution, which says Congress shall, upon 3/4 vote of all its members, propose amendments or revision of the Constitution. They want to put there the phrase, Congress, upon the call of either the Speaker or the Senate President, can propose amendments to the Constitution, voting jointly. Right now, there are 340 members of the House and the Senate. Now, 316 in the House and 24 in the Senate. So, right now, as the Constitution stands, the Senate must approve separately with the House. House and Senate must vote separately to convene Congress to amend the Constitution. There must be a resolution, like what we have now, resolution of both houses of the House, number 7 in the House and number 6 in the Senate. Those resolutions must be approved separately by 3/4 vote. So the Speaker alone, Speaker of the House alone cannot amend the Constitution, cannot call the Congress to amend because he needs the Senate also to do the same act. Both must pass that resolution, approve it by 3/4 vote, which is happening now in the House. What the present People's Initiative wants is the House Speaker alone can call Congress to amend the Constitution, and 255 votes alone can propose already, pass the resolution proposing amendments to the Constitution. So even if the entire Senate, 24 Senates will oppose that resolution, 255 votes from the House, all coming from the House, can approve it. So you have now disrupted the check and balance. Right now, for Congress to change the name of a national road, both the Senate and the House must approve a law. Even the smallest thing they have to approve, because the Constitution defines Congress as Congress shall consist of the Senate and the House. So this is bicameral. There is only one instance when the Constitution expressly says that Congress can act as one body. When they review automatically within 24 hours after the declaration of martial law or suspension of the privilege of the writ of habeas corpus, Congress must convene and vote as one. By majority vote, they can revoke or affirm the declaration of martial law or the suspension of the writ, but there is no other provision. So that is the exception, and only exception where Congress votes as one. The House and the Senate votes as one, and the reason for that, according to the framers, is that they wanted to make it easy for Congress to revoke a declaration of martial law or suspension of a writ. So the present in Lambino, I said, an amendment that alters the check and balance in Congress or in the structure of government is not an amendment but a revision. Any change that alters the check and balance or the separation of powers is a revision, because that is the jurisprudence in the US. We copied the People's Initiative from the US, and in the US, People's Initiative is good to amend only, not to revise the Constitution. That's uniform in all the states. And Congress and the framers of our Constitution, when they deliberated, they made it clear, this People's Initiative is good only for amendment, but not to revise the Constitution. And in fact, in the text of the Constitution, it says amendment or revision of the Constitution by Congress upon 3/4 vote or a constitutional convention. When it comes to the People's Initiative, it only says amendment of the Constitution by People's Initiative. So it's very clear that People's Initiative can only amend. But the proposal now is a revision because it alters the check and balance within Congress. That's very clear. Okay. So there is also another reason, the third reason why I'm opposing the present People's Initiative is that the proponents are saying, oh, we want to change the economic provisions. But when you look at the proposal, it's not economic provision they're changing the political provision. They're saying that Congress can meet upon the call of either the Speaker of the House or the Senate President, and they can vote jointly instead of separately. So it's a political provision. Now in Lambino, which I penned, I said that was a gigantic fraud because in Lambino, they asked the people to sign in blank. They did not show what is the text of the amendment. That's fraud. Here, the proponents are saying, we want to change the economic provisions. But when you look at the actual text that they propose, it's not about the economic provisions. It's about changing the political provision. So they are saying, oh, we will change first the political provision, and after that, once it's approved, Congress will now change the economic provisions. But why two-step cha-cha when you can do it with one-step cha-cha? One-step cha-cha means 13 billion pesos. You, Chairman Garcia of COMELEC said, to hold a plebiscite you need 13 billion. So for one-step cha-cha, 13 billion lang. But they're doing a two-step cha-cha. They're so generous with the people's money. So that's why I'm against the present People's Initiative. But that's not the end of the story. To be complete, you know, the Congress passed the amended Public Service Act, which really liberalized the foreign investments in this country. We allow now 100% foreign ownership of telecommunications, airlines, land transportation, sea transportation, many other things, retail trade, with just 10 million per store, you can open up already if you're a foreigner. So we have one of the most liberalized economies in ASEAN and in Asia because of the amended Public Service Act. But there is a problem there. There are two cases now in the Supreme Court questioning the constitutionality. In the amended Public Service Act, Congress defined the term public utility. Congress said public utility means other services but does not include telecommunications, does not include air transportation, sea transportation, land transportation, except public utility vehicles. So we all know, you're all taught that the Supreme Court is the final interpreter of what the Constitution says, the final interpreter of the provisions of the Constitution. What Congress has done was to interpret public utility in a law. And if the Supreme Court will say that is constitutional, the Supreme Court has no more function. It will become an appendage of Congress because Congress can now define all the terms in the Constitution by just mere legislation. That will strike at the very heart of the power of judicial review, the power of the Supreme Court to define the terms, to interpret the terms in the Constitution. So this is a clash of powers. There will be no more separation of powers because Congress now can just interpret the Constitution by law and the Supreme Court will just be pensionados. They really don't have any power anymore. So I think the Supreme Court will really strike down the amended Public Service Act. And that will be a black eye again to us. You know, when the Duterte administration said, we will not honor the arbitral award that Manila Water won in Singapore, we will not honor that. Although that was in the contract between the government and the Manila Water, that in case of dispute, the dispute will be settled by arbitration. But the Duterte administration said, we will not honor that. And that was a big black eye to us because the number one requirement of foreign investors is rule of law. If the government itself will not honor its contract, it's not honor what's written there in the contract, then they don't want to come here. That was a big black eye. Now this will be a big black eye if the Supreme Court will say the amended Public Service Act is unconstitutional because it's a usurpation of judicial power. And that is the problem now because we will have a double black eye. Nobody will come to the Philippines and therefore we have to save the situation. So I told the Senate, the way to save the situation is for the Senate and the House to vote separately to amend the economic provisions with the phrase, unless otherwise provided by law, subject to reciprocity upon 2/3 vote. So the Senate, there is now a resolution of both houses number 6 in the Senate, mirrored by exact terms except for the voting separately in the House, resolution of both houses number 7 in the House. And the House has approved it. It will be approved finally on 3rd reading this Monday. And the Deputy Speaker of the House, who is the floor leader, said the Senate leader, the House leadership has agreed that this must be voted separately. So if that is approved by both the Senate and the House, that will be first submitted to the people for ratification, that will save the situation because the Supreme Court will say, well, there is already an amendment to the Constitution that all these economic provisions will contain unless otherwise provided by law, and there is a law. The Supreme Court can let the Congress will delay deciding the two cases in the Supreme Court to allow Congress to pass a new Public Service Act to correct the deficiency, or the Supreme Court can just use jurisprudence. You know that if a Filipino sells land to a foreigner, that's unconstitutional. And it goes to the Supreme Court, but while the Supreme Court is deliberating, the land is sold by the foreigner to a Filipino, the Supreme Court will just say, oh, we don't have to decide the case because the land is already in the hands of the Filipino. The Supreme Court could do the same, that they don't have to decide the two cases because there's already a law allowing Congress to amend the economic provision. So reluctantly, I have to say that I am in favor of the two resolutions of both houses because it will be terrible if the Supreme Court will strike down the amended Public Service Act, as I feel it will, because that will be a big black eye again to us. The foreign investors will say, these people don't know what they're doing. We won't want to go to that country anymore. With that, I end my presentation. Thank you for your kind attention.
Thank you very much, Justice Carpio. So the disquisition that Justice Carpio generously gave us this morning is a very good refresher for our first-year constitutional law students. So first-year constitutional law students, you can very well join the debate in this ongoing issue of charter change. So to hear from the other side, let's now all welcome the next speaker. The next speaker is our very own attorney, Anthony A. Abad. He obtained his law degree from the Ateneo de Manila School of Law and obtained his master's in public administration from Harvard University. He's a panelist in the World Trade Organization's dispute settlement body, a chairman of the Philippines in the International Chamber of Commerce, a founding partner of the Abad Alcantara Associates law firm, and also a professor here in our very own Ateneo de Manila School of Law. So let's all welcome Professor Anthony Abad.
Thank you, Eugene. Good morning, everyone. To amend or not to amend, that is the question. So, first of all, let me state my position. Next slide. Amend. And then I take it further. Review and then revise. Now, let me disclose as a way of introduction, first of all, that you'll notice that there actually is no debate between Justice Carpio and myself. I should disclose that Justice Tony is actually my godfather, and together with the former National Security Advisor Jose Almonte and the late President Fidel Ramos is one of my mentors. So my career path, actually, I attribute largely to all the advice that Justice Tony has given me and set me on the path that I'm on. But this path also includes amendment. And you'll see there's no debate because actually we do agree on amendment, but the debate is with you. So the audience, the people coming here today and listening to this, the debate is with you internally and also amongst yourselves. And I would encourage you, strongly encourage you to debate on this topic because this is the most important topic, I think. In fact, I seem to be obsessed now or looking into all this, how to extend your life, longevity, health issues and mental health and all that. But why? Because I have a dying wish. And I wish that before I die, that we are going to revise
the Constitution. I hope, I mean, that's my wish. And that's why I will dedicate the rest of my career, my life, to seeing that this Constitution is amended and revised. And then keep in mind that even if it is amended within my lifetime, I know I will never see the benefits. I will never see the Philippines as a Vietnam or a Taiwan or a South Korea. It's my great grandchildren and your grandchildren who will benefit if we amend, review, revise. Okay, let's move. So I'm talking in general terms. Actually, I am appealing to you as the audience to study. Oh, yes. First of all, before I proceed, when you debate, when you make any statements in debate, we are in a academic institution. You are part of the academic community, students and teachers. Study. Do not make any statements about the Constitution without studying, without saying that I have read the Constitution and that I have compared this Constitution to other constitutions in other countries, that I have studied all the decisions of Justice Carpio and the Supreme Court on this matter, that I have studied the economic arguments, okay, of open economies versus closed economies, and that I've studied political science and the behavioral effect of systems like constitutions. So please, my appeal to you, study. Do not say anything until you have studied. Because my biggest problem is having to deal with people who argue against constitutional reform without studying. Okay, so what is a constitution? Okay, a body of basic laws and principles that describes the general organization and operation of the state, containing fundamental principles and norms that underlie and guide all government action. But it is the supreme law. It is the law from which all other laws emanate and base their framework. It articulates the rights of citizens. Institutions, procedures, or legislation must not infringe, and what the state must strive to ensure. The two main actors or characters in a constitution, that the constitution ensures certain rights and also imbues certain duties and obligations, are the state, how you limit the state and encourage the state to do what it should for society, and citizens. What are the rights of the citizens and what should citizens be doing for the state and for their society? Next. I'm here. This is Bernas quoting Justice Miller. The Constitution is a written instrument by which the fundamental powers of government are established, limited, and defined. And the powers are distributed among several departments for their more safe and useful exercises for the benefit of the body politic. In its pure sense, actually, a constitution or a charter is really for the purpose of organization. It's like a corporation has a constitution, has its articles of incorporation and bylaws. So in the same way, a country has a means of organizing itself. So the organization part is actually the most important part of a constitution. But then you have added also fundamental rights and obligations. So that's why there are bills of rights. There are certain assurances about the preservation of human rights, the duty to protect and defend the country, so on and so forth. Next. The significance of a constitution is that it defines this organization of government. It is the basis for the laws. So when Justice Carpio talks about what we can do and cannot do, it is primarily on the basis of the Constitution, and secondarily from the laws that emanate from it. So it's that important. But that means that it is, in effect, setting up a system, okay? A system by which we will It will define our behavior and the way we move forward. So our lives are actually determined to a large extent by what a constitution does. Next. So there is a book called The Behavioral Code, but there's an important item there that says that the Constitution is a behavioral code for society, just like laws are. And I see my friend and colleague Orion Perez Dumdum, also Ateneo. But he had an important insight that he says a constitution is like an operating system. If you think of an operating system, you think of your lap, you look at your laptops and your phones, there is an operating system from which all programs are run. Okay? But what do we notice about operating systems? Especially, sometimes it's annoying, but the computer will ask you, update. Okay? And then you say, okay, update. Or it automatically updates. But it always updates. So you don't have an operating system from 1986 or 1987 that's still running your programs. That has already long been updated. And constitutions around the world, they may be the 1776 Constitution of the United States, but it has undergone a number of amendments. So, next, Constitution is a living document. Okay? It is not something that is set in stone. Okay? And that means that we have a duty to actually review this Constitution. Why review it? Why look at it? Okay? But first of all, let's not get too paranoid about any attempts at amending or revising the Constitution. Like I said, it's something natural. It's something that all citizens should do. That means it's our duty, a collective duty of society, because this is our document. So if it's our document, we have a right to look at it. We have a right to revise it. Now, I quote from Thomas Jefferson in his letter to James Madison that no society can make a perpetual constitution or even a perpetual law. Okay? So please keep that in mind. I go further. As the earth belongs to the living and not to the dead, a living generation can bind itself only. In every society, the will of the majority binds the whole, meaning that the living generation should not be bound by the dead generation. Most of you here were born after the 1987 Constitution. Most of you belong to a new generation. And this is 2024. It's not 1986. And in 1986, there were extenuating circumstances, just like there were in 1970 to 1973, emergency situations that called for the passage of a constitution by a wholly appointed body, not elected, but appointed body, to be able to legitimize the revolutionary government of the Aquino administration. So it was out of necessity that we had to accept it and ratify it. But I did it also. I accepted and ratified. I joined in. I voted for it, but with a very heavy heart, because as a student of law, I was really looking forward to our shift to a parliamentary system, unicameral at the time, unicameral body. There were all these great opportunities that were missed. But that was 1986. I'm saying it's 2024. This is a new age. So why not? Okay. And in fact, Thomas Jefferson even says every constitution then and every law naturally expires at the end of 19 years. He actually says this, his estimate of how long a generation lasts. If it be enforced any longer, it will be an act of force and not of law. Okay. A constitution is crucial to the country's ability to thrive in the global economy. Being in the new age also means that we are not living in a vacuum. We are not North Korea or maybe Cuba of a few decades ago. We don't live in isolation. In fact, we are so wired and interconnected with the rest of the world. We cannot ignore what happens outside of the Philippines. And our ability to thrive and prosper in this global economy depends a lot on our own laws, how we circumscribe ourselves or limit our abilities and our powers. That's why a constitution is so important. It's not just a local document that defines how we do things inside our country. It actually gives us the ability to thrive outside. But that means that a constitution is actually part of the legal system that can actually empower us. So it's an opportunity for us if we review and revise on the basis of being part of this global constitution, global economy. Next. According to Dr. Ernst Ulrich Petersmann, the constitution of a country is part of the international economic legal system. So I'm a student of international economic law, and I'm very thankful to my students in my class who have worked very hard to help me with this presentation. And they know that in the study of international economic law, we're not just talking about treaties and agreements. We're not just talking about the World Trade Organization agreements or the ASEAN agreements, but also national laws, and importantly, a topic that has not been really touched on, that constitutions actually are a tool for us to work within the international economic legal system. So consider the constitution as part of IEL, International Economic Law. The problem is, instead of being an opportunity, or a means of empowering or a tool for empowerment, it has become an obstacle to stimulating or enhancing our economic development. We are way behind. And as Justice Tony said, that we are even in danger of further giving ourselves black eyes. But we already have black eyes. And it has to do with how we have participated in the world economy. It is a statement on us and the effect of being a closed economy versus an open economy, closed society versus an open society. Now, I think we can probably argue on whether a 60-40 actually allows for enough investment to come in. I mean, there could be empirical studies on this. But as a corporate lawyer, considering investment into the country, the problem is clientele, potential clients just take one look. Said, oh, okay, let's consider the Philippines as an investment destination. Is it friendly to investment? Compare the constitutions. When they look at ours, they take one look and see things like 60-40, or this is prohibited or that. And it's a signal to them that says, well, I think I'd rather deal with a country that does not have these provisions in their constitution. So there's Vietnam, Cambodia, etc., etc. It's that decision point that I worry about, and why it's so important that we deal with the problem. Next. The problem, and I think this is something I've learned actually thanks to Justice Carpio and NSA National Security Advisor Almonte and President Ramos. The problem is we are a closed economy. So at the domestic level, we are highly concentrated, still dominated by monopolies and cartels, but hopefully dealt with by competition law. And at an international level, still not embracing the integration process that's happening in the rest of the world. Next. Okay, so let's take a look at our constitution. The question of what to amend, let's say amend. It's the economic provisions that seems to be the important issue right now. But I will go on and explain why we must go even further than that. And this is information's care of a friend of ours, Dr. Emmanuel Doy Santos. No? So very happy to learn about these things. The 1899 Constitution, or the Malolos Constitution, was our first constitution, designed largely similar to the Spanish Constitution. No? It had also separate bodies, and it separated the head of state and the head of government. So you actually had a president of the state and a president of the government, who's in effect the prime minister, elected from the assembly, no? And not popularly elected. And the Supreme Court, or the Constitutional Court, was headed by a president also, a presidente. Okay. This constitution did not have any economic restrictions. Okay. 1902, we had the Philippine Organic Act, our first constitution under the Americans. And here's the interesting part, that US companies, particularly with thinking about US, no? It is the United States that controlled the Philippines, but it was the United States colonial government, insular government, and the federal government that restricted US companies from coming in. And there is a historical basis to this. And Dr. Santos pointed out that in a Harvard Business Review, looking at the history, that there was a conflict between the Democrats, who were against colonization or against annexation of the Philippines, and the Republicans under Theodore Roosevelt, who wanted to push through. So as a way of assuring that, well, it would not benefit big business in the US, they put these restrictions. It was unique at the time. It was unique in all the world. No other country had these kind of restrictions. So actually it came from the Americans. But these were prohibitions on land ownership, banking, mining, and utilities, no? Or those that are franchised. These restrictions then carried over into the Commonwealth period and the 1935 Constitution. But their modification here, and this is something I take issue with, is the use of 60-40. So it was a compromise, no? That you allow certain investment, but it's also restricted. But in effect, it becomes restricted, or you try to find a way around it. No? 64. Next. The restrictions still found themselves even in the 1973 and in the CONCOM. Now, why was the Philippines a powerful or strong economy in the 1950s? In 1946, what happened was there was an amendment to the 1935 Constitution that allowed for parity rights. So it allowed for US citizens to have the same status as Philippine citizens. That means they actually effectively now allowed Americans to invest in the Philippines. And the American economy, of course, the strongest economy in the 1950s. So it carried the Philippines, no? And we were the strongest economy, even stronger than Japan at the time. However, our protectionism got the better of us, so that by 1974, when parity rights had been lifted, we were a closed economy. Closed economy not only in the Constitution, but in other laws and international trade. So what I learned was there was a lot of barriers to trade because they were trying to protect local industries. In the 1987 Constitution, we had an opportunity to correct this, but unfortunately, we even added on to the economic restrictions. Next. These are the economic restrictions. The Congress resolutions that are now being debated or being approved have to do specifically with education, advertising, and public utilities. So it's only limited. But my position, next slide, that the Constitution must not legislate what the legislature can legislate. Okay. So what is the role of a Constitution? I go back to what I said earlier. It's really basically to organize ourselves, an operating system, It is a means, as a foundation for our legal system. Do not put in specific provisions like 60-40 without allowing the legislature to go through the debate and the legislative process, and also to allow a legislature to correct or to amend and change things along the way. Because you don't want to set these things in stone. The problem is, here we are, we're stuck with these provisions. So I actually support Justice Carpio's position that we have to amend the Constitution to properly address the issue of economic restriction, since there is a problem with the Public Service Act amendments. It's not sufficient, it's not proper. So actually what we should be doing is amending the Constitution. You amend through Congress, a constitutional convention, or initiative and referendum. I actually do not disagree with Justice Carpio on how we should amend the Constitution. Ideally, in fact, if you're talking about a review and revision, we should really go through a constitutional convention, because then it gives you a more objective way of changing the Constitution without the interference of the current political officials. However, Congress itself, as two houses, can also amend and revise. But an initiative and referendum should be for amendments, as Justice Carpio pointed out. I am part of the, as a matter of disclosure, I am part of this effort for a people's initiative, because I am a resource person for the groups, okay, like PIRMA, CORE, correct? That, well, what these groups actually really want is really to review and revise. I mean, their aspiration is actually to see us as a country review and change our Constitution. However, on a practical level, the problem they saw was that it would never get past the Senate. And so their idea was that amending, okay, that provision on how you vote was a way of addressing the problem. But of course, ideally, we'd like one that has the consensus and support of everybody involved. So Congress can do its individual amendments, for example, with the economic provisions, and it's probably going to be the best solution. Parang it will resolve any of the conflicts that are happening now. But eventually, I think we should be looking at a constitutional convention. Next. Okay, I won't go in detail through this. I just have to cite that there are country examples. And I say study. Don't just study our own constitution. Study other constitutions. Study other countries. And always, if they can do it, why can't we? Has Vietnam, Singapore, Thailand, can any of these countries be accused of being less nationalistic? I think Vietnam is probably the most nationalistic of countries, most patriotic. But it's open to investment. They don't have this paranoia. They don't have this convoluted idea that to do a 60-40 is being patriotic, is being nationalistic. They're practical. They're pragmatic. Capital. What is the nature of capital? Capital just wants to find its return on investment. It's not there for some ulterior or evil motive. No? But there are means of making sure that national security and public interests are protected, but it should not be 60-40. Okay. And of course, well, I always like to cite Vietnam, my favorite country now, because they've come from war, they've come from terrible poverty and famine and suffering, but they have, in a 10-year period, lifted 40 million out of poverty. There are no absolutely poor people in Vietnam anymore. Everybody is well fed, everybody is taken care of, and they're open to investment. and they're nationalistic. And they're doing very well. They're accepting of new technologies. You travel there, it's a modern country. It's approaching already, it's looking like a developed country. So again, please study these country examples as a means of laying the basis for your own debates on the Constitution. Vietnam was able to attract $36.61 billion. We're happy already when a few $100 million come in. No? We put it in the newspapers and all that. But compared to 36.61 billion, we just get 1 billion. And we're happy with that. But to overcome poverty, to actually achieve a truly resilient and inclusive society, you require capital accumulation. So Adam Smith, all the way to Danny Roderick, will attest to capital accumulation as the key element in alleviating poverty. And of course, with capital accumulation comes technology transfer. And technology will solve many of the problems that we suffer now. It will address our peasant agriculture, okay? Because we're still under a peasant agriculture economy. We want to be like the Vietnamese farmers who are rich, you know, and they like to show off their jewelry. Or in Korea, they said that, well, the joke is that you can tell somebody is a farmer in Korea because they use E-Class. Not S-Class, but E-Class, Mercedes. Okay. One step further, review and revise. That means we should actually take a long, hard look at our 21,000-word Constitution and see how we can improve on it. Why? Why bother? No? Parang, aren't we okay already? No, we're not. Next. The world is changing. This is a new age. 2024, of course, is very far away. It's 37 years away from 1986. But also, this is the age of AI, artificial intelligence. And what I'm studying now in international economic law is the acceleration of the economic integration process as a result of AI. AI is a reality we cannot turn our backs on because it's going to assist every aspect of our life. Our daily activities will be affected by this. So, we need a constitution for the future. Again, I repeat, it's not for us, hopefully for you guys, but more importantly for your children and grandchildren. You owe it to them that we're way over the 19-year limit set by Jefferson. We have to look at that Constitution and study it. Let's just study it and let's just talk about it. Okay? Let no more of this refusal, absolute refusal to even discuss it. It's this childish, and I said it's unstudied, and it's, you know, in an academic institution, it's shameful, no? When you don't allow for the debate, when you don't allow for the discussion. We need a comprehensive review and revision, ideally through a constitutional convention. Again, why? Because a constitutional convention will be elected individuals for this purpose. They are not the same people that you see in Congress. I think Justice Tony will also emphasize that, you know, preferably voted by, not by the same districts, no, as Congress, but through another means such as through the provinces or regions. No? So I'm thankful to Professor Arroyo and all of you in the society who have taken the effort for this event. I was very nervous because, as I said, Justice Tony is my godfather, and I don't want to say anything that would embarrass him or embarrass myself. But as I said, the debate is out there. We actually agree. But the debate is out there, and I appeal to all of you, please, at the very least, let's take a look. Let's study. Okay? Study, study, study. and then change for the good, change for the future. So on the economic provisions, yes, amend, but also review and revise. That's my position for today, and be happy to answer questions later on. Thank you very much.
Thank you very much, Professor Tony. It just dawned on me moments ago that we are actually flanked today with two Tonys, Justice Antonio Carpio and Professor Anthony Abad. So I've been thinking of some creative titles for this debate. We can call it the Battle of the Tonys, or we can call it the Tony Debates, or A Tale of Two Tonys. Okay, so from the speakers, we can actually draw some fundamental questions. And as what Professor Tony has pointed out, we have to be able to study and participate in that debate. And in order to do so, we actually have to ask some fundamental questions. And from the exchanges between the speakers, there are four key questions that we can actually draw from what they said. First is, why? Why do we need to change the Constitution? What is the rationale for changing or not changing the Constitution at this time? Second would be, is this the right time for changing the Constitution? And third would be, what would be the most appropriate modality to change our Constitution? And after answering those three questions, then it could possibly lead now to this fourth question. What would be the provisions now in the Constitution that we want to see changed? So on that note, we'll give the floor back. We would like to welcome back Justice Tony for his rebuttal for 10 minutes to the remarks given by Professor Tony Abad. Justice Tony?
Well, if we have to amend our constitution or revise our constitution, I think the best way is to call for a constitutional convention. Because if we allow Congress to amend or revise the constitution, you will probably see Congress lifting the term limits. You will probably see the provision on political dynasties deleted, because that will be against their personal and family interests. So I think to be neutral about it, we should call for a constitutional convention, and the delegate should be elected not from the district, because that means if it's by district, the incumbent congressman will just let his or her spouse run or the children run for delegate, and we're back to the feudal system again. So the solution to that is to elect the delegates at least province-wide. In the 1970 Constitutional Convention, Metro Manila was taken as one whole unit where you can run. So we got very good delegates there. You had Voltaire Garcia, you have illustrious lawyers elected as delegates, because the political warlords could not control areas larger than their fiefdom. So I think we should strive to have a constitutional convention, because we have to get the best minds, and we must have historians there. We must have lawyers, not only lawyers, we must have doctors. All sectors of society must be represented. So when we talk of constitutional amendment, we should think of a constitutional convention. Thank you.
Thank you very much, Justice Carpio. Would like to call back to the floor Professor Tony for his rebuttal. Sir?
Rebuttal. Well, you say, why is he agreeing with Justice Carpio if it's a rebuttal? I do. So in terms of history, we are, well, this is a problem that I also face. I think we face a certain amount of trauma, or we deal with a certain amount of trauma because of the martial law era. As Justice Tony pointed out, no, the 1971 CONCON, or Constitutional Convention, um, had many luminaries, very respected people at the time. It's really a hall of fame, so to speak, if you're going to go through the list of Constitutional Convention delegates. And I think we owe it to their memory and their effort, no, that we continue on that type of work, the Constitutional Convention, which is really to review and go through the different provisions of the Constitution for an upgrade. No? What was the problem is that they were proposing a shift to parliamentary system of government. What is it about parliamentary systems of government? Parliamentary systems, when correctly applied, will prevent authoritarianism and dictatorship. Also, it's much cheaper than a presidential election. But the problem with the presidential system of government, especially when it's popularly elected, is that we stop at the election process and we give up already, okay? Because the president has all these superpowers that are in the Constitution. Most important is the power to budget, the power to spend. In a parliamentary system, you cannot just spend, because the parliament as a people's assembly has to go through every item, every peso or every dollar that's being spent. And that's the thing about parliamentary systems of government. They really are the house of the commons, of the people. And our CONCON in 1971 was proposing a shift to a parliamentary system of government. So I understand, I think Diosdado Macapagal was hoping to become the first prime minister in this batasan, or interim batasan. He was a president of the CONCON, by the way. The fear that he would lose his power, my theory, my own theory, is what motivated Marcos to call for to declare martial law, for using many other reasons, such as the first quarter storm and threats to national security. But actually, it was really a power play, that he wanted to make sure that the constitution that came out in 1973 would be in his favor and he would still be in power. So what happened? The 1973 constitution was ratified by barangays, no? Barangay councils. But he used his emergency powers as dictator, or as martial law leader, to amend it, and rendering ineffective the parliament. So the parliament lost its power. It became a rubber stamp as presidential assemblies become. What's the problem? If you have the budget, you, one person, no, you're tempted, the politicians who will populate your Congress, no, will naturally gravitate to where the money is held. It's different in a parliament who holds the purse. Everyone gets to take a look. No? Maybe you can study the Bangsamoro model now. They have a parliament, no? And they have to go through this parliamentary process. But it's that sort of democratic space, that participation, that Marcos was afraid of. Again, my own theory. And that's why he declared martial law and wanted to stay on in power. If we are afraid of dictatorship and authoritarianism, we have to again revisit that. Let's take off where the 1971 CONCON left, or where they were stopped. No. And remember that the 1987 Constitution is an emergency constitution. The question of whether it's the right time, maybe it's not the right time, because the right time should have been 1990, or 5 years, something like 5 years after the 1987 Constitution. was passed. That would have been the best time to do it. And maybe we would be still ahead of Vietnam. But this is economic reality. That's what I'm trying to marry. Economic realities of the world with the proper organization of our society. Also, you have to think about a society, when we think of constitution of the future, it's an inclusive constitution, a constitution where we all work together. That is why you need a parliament that provides for coalitions or for the spectrum of political points of view. Then political parties will matter because they will represent these different policy points of view. That's the idea and concept behind parliamentary systems. Maybe a word about federal. Okay, and I know maybe we might not agree on this with Justice Carpio, but federal again is a political solution for enhancing or ensuring the unity of different diverse geographic groups within a country. And even a country as small as Belgium, okay, just to resolve the differences between the Walloons and the Flemish, they shifted from a centralized unitary form of government to federal. Spain, Mother Spain, actually has a de facto federal system. It has addressed the violence that was coming out of the Basque country and also the tensions with Catalonia. But the rest of the country also said, we want to be part of that. We also want autonomy. Café para todos. Yeah, café para todos. They said, we also want to have the coffee. So that's also an interesting model to study. But again, I'm throwing it out there for your thoughtfulness and study. Ano pang questions na ano? Why? I hope I already explained that. How? I do agree with Justice Carpio. In the end, the best way to review and revise is a constitutional convention. Because again, practically, I cannot see Congress engage in restructuring of the political system. They already have figured it all out. They're in power, and they have their dynasties to ensure that they stay in power. So it will be difficult to imagine them proposing a new system of government. And that's why a con is probably the best. But for economic provisions, Congress, okay, the two bodies working separately. Okay. The People's Initiative or the Initiative and Referendum is really a means of, well, there's a signal to Senate that we're looking for a way to amend the Constitution so that whether you block it or obstruct it doesn't become material. But then if both houses can really work together, then they can put all of these meaningful amendments. I know that the economic provision amendments that are being proposed, they're just adding the phrase, unless otherwise provided by law. Ideally though, again, my personal position is that you should just take it out completely. You should be silent on economic restrictions. But notwithstanding that Congress itself can impose the restrictions. Like in other countries, it's their parliaments, it's their legislatures that enact laws that restrict investment or at least provide some form of oversight for investment. So we can provide oversight for investment such as national security concerns, strategic utilities such as telecommunications and energy grid, for example, or electricity grid should be subject to some form of national security review. It's not the 60-40 that's going to protect us, but it is national security provisions. Also public interest, such as public safety, public standards, consumer welfare, competition law. We're not saying that these new investments are going to be exempted from all that. They will have to follow the law just like Philippine enterprises follow the law. And that is our protection. So there's nothing to fear. And again, look at the other countries. They've done it. They've succeeded. In this world, based on a study by Johan Norberg, there's empirical evidence to show that the most open economies, the ones that allow investment and trade, are the ones that have been able to overcome poverty, actually going from absolute poverty to zero absolute poverty in a short period of time. And short is, of course, 20 years, no? 10 to 20 years. If we start now, like I said, I'm waiting 10 to 20 years. I don't know if I'll be able to live that long. I hope I can. And I think I can stop there. Thank you.
Thank you very much, Professor Abad. I must confess, coming into this debate, I belong to that other side of the fence where I'm opposed to any change in the Constitution at this time, because especially I share the common sentiment that it's particularly because of the distrust that we have. But after hearing Professor Tony and Justice Carpio, we can actually draw from their exchanges that there are two things that they actually agree on. One, obviously, the possible mode of amending the Constitution or changing the Constitution now would be through constitutional convention. And that would seem to be the more acceptable modality when the time comes. And secondly, and notwithstanding which part of the fence you are in, we can never deny that from the two legal luminaries, we can actually sense that they all have that same of love of country. And that is that same spirit that moves now to our discussion this morning. So this juncture, we'd like to call on Justice Carpio and Professor Tony Abad to the couch so that we can have a more informal, loose discussion. So this is the part now where we invite the audience to interpose questions so that you can earn the incentives. Okay, I feel like I'm the third man in the ring. So I'll start the questions so that the others can follow. So I have a question each for Justice Carpio and Justice Tony Abad. I promoted you, Professor Tony. For Justice Carpio, sir, surely there are provisions in our Constitution, even if they're not economic, that's already time for amendments or changes. So what do you think are these political provisions that can possibly be changed already at this time?
Well, my pet proposal is that the justices of the Supreme Court should be appointed equally, 1/3 by the President, 1/3 by the Congress, and 1/3 by the Supreme Court itself, just like in South Korea. In other words, we have this state of utang na loob. If you are appointed by the president, you tend to vote for that president no matter what. So to address this cultural issue, the Koreans have divided. So the appointees are not loyal to just one person. And it's a very practical solution. So I suggest that the justices be appointed 1/3 by the Congress, 1/3 by the Supreme Court itself, and by the President. And also that members of the Judicial and Bar Council, right now they can be appointed and reappointed ad infinitum. And of course, if you are appointed there, you have a term of, I think it's 4 years. You want to be reappointed. So whatever the president says, recommends to you to nominate these people, you just follow because you want to be reappointed by the president. So just like in the Civil Service Commission, the COMELEC, there's only one term. You are appointed for a fixed term of 7 years and that's it. We should follow that also. So that's for the judiciary. Now, I have not really delved into the two other departments. Thank you.
Thank you very much, Justice Carpio. So, for Professor Tony, what are your thoughts, sir, about those who are against the changes? That when it comes to the economic provisions, the ills of this country is not really so much on the economy. In that, if you look at the trajectory of the Philippine economy from the time of the passage of the 1987 Constitution to the present time, you can actually see our economy progressing, improving. So that's why there are critics to those or to those who are opposed to the changes to the economic provisions. It's not really what this country needs at this time, and that the problem is not really in the economy, but in our systems in place in government.
Okay. Countries will rise to the level of, well, they'll rise according to the world economy's activity as well. No? So, world activity as it happens and there's international trade and investment going on, it does pull up countries. So countries will show a positive trend most of the time, no? Unless something devastating happens in these countries. So same thing with the Philippines. No? But what we are looking at, what we really need, no, is a trajectory of growth that can overcome the poverty cycle. Because that's our problem, is sort of we're stuck in this this vicious cycle of underdevelopment. So you need to leapfrog over over the economic level that we have. So it's not sufficient, I think, to just sort of creep up or rise slowly while the rest of the world is moving quickly. And then chicken and egg. No? My analogy here is if you have cancer, Dr. Jose Rizal refers to a cancer in society. You know? If there's a cancer, are you just going to deal with the symptoms? No? Oh, he has a cold. Let's give him some cold medicine. Let's address this. You know, let's address these small issues, the sort of the low hanging fruit, the easy to solve, you know, the non-controversial. But underlying that, fundamental problems, no? About how we elect people, how we elect our leaders. Again, how much transparency there is in governance and expenditure, no? Which is key, I think, in the form of government. And then the openness, no? As I said, the decision to pump in trillions of dollars, no, is something that also goes to the level of trust and confidence they have in the economy. Their perception, and unfortunately, the world suffers from a perception bias. No? So when they look at the Philippines, Philippines not really open for business, sort of open for business, but not really open. In a way, no, in a dramatic way that you'd see maybe a nascent Singapore or a nascent Taiwan really sort of, you know, dramatically improve themselves. No? So it's really for this reason that I would prioritize your fundamental law, your foundation, and then you can start really addressing the other issues. In any case, these two can always run in parallel. Doesn't mean that because we are dealing with the Constitution, we're not going to deal with all of the other issues like preventing crime or addressing the short-term issues. These two can run in parallel.
All right, thank you very much, Professor Abad. So we'd now like to open the floor for questions. Kindly state your full name.
Thank you, Atty. Cao. I'm JB Wak ng Beherin po. I'm a first-year law student from Block 1C. This question is specifically addressed to Attorney Abad, if it's okay. Sir, you mentioned that the review via CONCON would be the most ideal way of changing our constitution. You also mentioned that proponents from the House resorted to the People's Initiative because they saw that past reforms have been stalled because of the Senate. As one of the advisors of these groups currently pursuing constitutional reform, would you say that the People's Initiative recently executed was a genuine one to pursue constitutional reform in the Philippines?
Yeah, let me give some background. No, first of all, it's not the House that initiated it. It is these groups that have, through the decades, actually, PIRMA, CORE, Constitutional Reform Group, which was actually during the Duterte period, and the Correct movement of Mr. Dumdum and others. No, and then there are other groups that are also well, lining up or preparing to join. I think they genuinely or sincerely want constitutional reform to happen, and they're looking for ways. No, they've seen that the attempts, no, over time, well, according to the House, 358 attempts to introduce changes to the Constitution since after the post 1987 ratification, and a sense of frustration with the structure of trying to introduce amendments. So I know that, well, the logical thing would have been for these groups to go straight into their economic provisions, but they were worried that the Senate would not agree to this. So they wanted to introduce the change in the way you vote. No? Now, why are the House, well, why is the House supportive? Because you have to get 12% and 3% per district, which means that you have to let the House know that you're doing this, no? Which is why they went and talked to the House leadership about it. I understand they're still, I'm not involved in the signature campaign, but I understand they're still collecting signatures up to now, in spite of the COMELEC suspension. And perhaps what will happen is, well, it will become moot and academic if both houses actually go ahead and amend the Constitution.
Thank you, sir.
All right, thank you, Mr. Beherin. Any other question from the floor? Go ahead, please. We can actually entertain one or two more.
Hello. Good afternoon. I'm Paeng Marbella from Block 4D. I think what really struck me was in your presentation, Attorney Abad, you said you had that quote na the Constitution shouldn't legislate what the legislature can. And I actually grew up in the States, so we had basic na consti stuff. So I know in the US, the Constitution, there's that debate between the textualists and those who want the Constitution to represent what the current realities need. So I just wanted to I just wanted to hear a little bit more about that statement, because it's not clear to me in the Philippines where, like, we're a relatively young republic. So, and we've gone through so many constitutions. I just want to know, if we were to create a new one, would it be something like the US that's it's very general, that the Constitution is turned very general, and it's really the Supreme Court that tries to make sense of it? Sorry, medyo long.
No, it's a good question, because it also makes us think about our Constitution. No, I think, in fairness to the CONCOM, Constitutional Commission, they were under time pressure to come up with a Constitution. I would liken that Constitution that they came up with, the 1987 Constitution, as a first draft, sort of a first draft thesis. It's much longer than it should be. But a Constitution, as I also pointed out, is a very basic document. It's your organic charter. It talks about organization. And if you look at other constitutions around the world, even countries like the United Kingdom doesn't have, strictly speaking, a constitution, no? But only certain articles, and a lot of it is in the form of jurisprudence. No? So a constitution, I think the lesson there is a constitution should be flexible and dynamic, but provide enough guidance for society to work around it. No? And that's why the US Constitution actually although they still say it's the original constitution that they passed, it's undergone such dramatic changes already by amendment. Same thing with the constitution. If you're from the US, constitutions of the various states, no?
Yes.
They also have their own constitutions. They also go through they also go through referenda. No? But you'll see that there is a certain dynamism to constitutions, and I think that's what we should have also. When I say the Constitution should not legislate what a legislature can legislate, yeah, there is a fine line. There's no rule or hard and fast rule. But when a CONCON really gathers, it's talking about this document for the future. No? So when you start doing things like putting very specific provisions, that's already legislation.
Okay.
That you're taking that away from the legislature that you're creating.
Thank you.
Perhaps we can also hear the thoughts of Justice Carpio.
Well, the Senate conducted a survey of 18 countries in Asia, and none of these countries have embodied economic restrictions on their constitutions. So it's good to allow the legislature to provide for economic policies, because the economy could change. No? Yeah, it's good to remove the economic restrictions. That's why I'm in favor of putting there unless otherwise provided by law. But we have to have reciprocity. Right now, if you go to Vietnam, you cannot buy more than 49% of a telecom company. You can go to China, you cannot buy 49%, more than 49% of a telecom company. You cannot buy their airports, run their airports, seaports, and transportation companies. But we have opened up. Now, there's a provision in the amended Public Service Act, subject to reciprocity. All of these new openings is subject to reciprocity. I actually recommended that to one congressman to insert that in Congress, in the bill, and fortunately it was approved, and approved also by the Senate, because it will be crazy if we open up but we cannot buy into their companies. So there should be reciprocity. And even Europe now, because of the experience with China, China is buying up their companies, but the Europeans cannot buy companies in China. They have required now reciprocity. And even the US now has latched on to this reciprocity. So I think the countries of the world now are requiring reciprocity. And that's why I have strongly recommended to the Senate and the House to include reciprocity. I also said that we should have a higher threshold, because from a constitutional provision, we are bringing it down to being amended by Congress. So it should not be a simple majority, because Congress can pass a law by a quorum of a majority. So less than 50% actually. So we should put there 2/3, because this is a very important legislation. Thank you.
Thank you, Justice.
I just want to add, only the country examples though, like China and Vietnam, is all in legislation. It's not, these percentages are not in their constitution.
Vietnam, China, they prohibit more than 49%. That is in their law. Yeah, but they still prohibit. But we have opened up 100%. Were it not for that subject to reciprocity, we would be at a disadvantage. China can buy 100% of PLDT, but we cannot do the same in China. So that reciprocity is very important, because it will be crazy to open up our economy. We have 12 million people outside, Filipinos, and they cannot even buy companies in those countries, and we have allowed those countries to buy our companies. There should always be reciprocity. That is now the number one condition of EU and the US, because of their experience with China. Thank you.
Thank you.
Thank you very much, Justice Carpio and Professor Tony. Perhaps one last question, sir?
Thank you. This is really, I'm Al Mayorago. I should have been a lawyer when I went to college, but many people call me attorney now, even if I'm not a lawyer. But anyway, this is addressed to both them. I think the end all of the Constitution is to really support the basic needs of a people, if I were to summarize. No? And Attorney Abad, you mentioned that what we really need in this country is to address the key problem of poverty. We need a new trajectory of economic growth, lest we go back to the feudal system, as Justice Carpio said. No? So I was looking for potential solutions from your presentations on how to approach that. And obviously, as the moderator said, there is a key distrust issue with our leaders. I think part of the reason we're having this brouhaha on this con thing is because we simply do not trust our leaders and that they will act in the good interests of the people. Okay, so my question is, you proposed something like a parliamentary system has the potential of actually becoming, what did you call it, a House of the Commons, where there could be real, authentic public review of programs. And more importantly, did you say that that the power of the purse, the people will have a say, as opposed to what's happening now that the power of the purse is in Congress? Because I think that has real implications on inclusivity and people involvement in the design of political programs, economic programs, and control of the purse. So could you elaborate on that possible solution, sir?
Okay. Thank you, Attorney Al. We're village mates. No?
Yes.
And thank you again for your question. Yeah, it's in parliamentary systems. You know, it's the reason why it's a House of Commons. No, is really a reaction to absolute monarchy. No? That they had to. That's why there was really civil war just to establish a parliament, because the parliament would now represent the people. No? I know. Okay, I know that. Well, there is a general distrust of politicians for good reason. No. And that's why Justice Tony and I actually, well, in the end, we say constitutional convention, so that you distance the drafting of a constitution from those who are currently in power. No? But yes, the difference here is actually the president has the power of the purse. No? The president, through his Department of Budget and Management, I mean, technically, it's supposed to be the House of Representatives. No? That or initiates the discussions on budget, but really the power is with the president, and those who are in power, the politicians involved will naturally gravitate towards the president. No, and that's why you don't really have the kind of discourse and debate in Congress that you would have in a parliament. No? And I know it's not a perfect system, but it's a better way for us to look with a certain measure of transparency at how money is being spent. And that's, in the end, it's the one of the three important roles of government is the provision of public goods and services. Public goods and services, because the private sector would not otherwise invest in this. So government has this role of providing public goods and services. But you want to make sure that every centavo is spent properly in public goods and services. there is unfortunately an opaqueness, I think, in the current system. Maybe we don't really have access to looking at the centavos and the pesos being spent. And that's why, and also the accountability leads to a certain amount of impunity in the disposition of what, 13 trillion pesos. And that's a lot of money that can be used to reinvest into the country. But if you don't have a way of really looking at how it's spent while it's being debated or while it's being deliberated, then it will naturally lead to the abuses and the issues of corruption that we are familiar with. I hope this answers your question. I'll also ask Justice Carpio to.
Yeah, the issue of distrust has really played a large part in this constitutional crisis. For the longest time, there was no agreement how Congress could amend the Constitution or revise the Constitution, because the old Constitution, the 35 Constitution, which was bicameral, says Congress in joint session assembled can propose amendments, voting separately. So it was very clear. But in the present Constitution, it says Congress upon 3/4 vote can propose amendments. So there is a question, should they hold a joint session, and should the voting be joint or separate? And that's the reason why up to now, there has been no effort to amend the Constitution by Congress, because the Senate has always been scared that if they enter into a Constituent Assembly, if they join the House in one assembly to amend the Constitution, the House will say, we can outvote you. And the issue will go to the Supreme Court, and the Senate is not sure if they can win, because the framers of the Constitution forgot to change, because the original proposal in the Constitutional Commission was a unicameral body. So all the provisions were did not contain voting separately because it was a unicameral chamber. At the last minute, the bicameral body won by one vote. So Justice Escudero was a delegate and was asked to harmonize everything, and he told me he missed that portion on Congress shall upon. So there is that issue, and Senate was always afraid to go into a joint assembly with the House because they could be outvoted. But the breakthrough came recently. I was watching YouTube the other day, and the Deputy Speaker of the House, the floor leader, said that the leadership of the House has agreed that House resolution of both Houses 7, which they're considering, should be voted separately. And the Senate will vote separately on the counterpart provision. So we have here an agreement already. The crisis has been resolved because the House has expressly agreed that it will be voting separately. Before, the House never agreed. And therefore, the Senate would never agree to meet jointly. So now we have a happy ending, and that's why I'm saying let's just do it, because that will resolve the crisis, and that will also solve our problem on the amended Public Service Act. I hope that this Monday the House will pass that resolution, and now it goes now to the Senate. The Senate will have to adopt the same resolution, and they have 17 votes now. They need only one vote. I think they can get another vote, and we will have 18 votes. Then we have resolved the crisis. There is no more constitutional crisis because both chambers of Congress have agreed it will be voting separately. They will discuss it separately, just like an ordinary legislation. And it will be submitted to the people for ratification, and I think it will be ratified. Thank you.
Okay, if it's all right with our distinguished speaker, one very last quick question. Yes, please, go ahead. Attorney Dumdum, is it?
I'm not an attorney. I'm actually a computer science graduate. I actually work in IT, 24 years in Singapore, IT, but I am the co-founder, the principal co-founder of the Correct Movement, Constitutional Reform and Rectification for Economic Competitiveness and Transformation. My IT background is very obvious with the comment that my friend, Attorney Tony, or Professor Tony, mentioned about my description of the Constitution as an operating system, right, that needs to be updated. My question actually is for everyone. It's for everyone and of course our panel. Why is everyone always fear-mongering about constitutional reform being about term extensions? Always. At every instance, ever since the 1990s, term extensions ang problema daw. Term extension, term extension, term extension. Chacha na naman yan, term extension na naman yan. Term extension lagi ang sinasabi. But what exactly is a term extension? I only know of two instances, maybe people can correct me, but I only know of two times that there was a term extension for a president. World War II, Quezon was supposed to step down, but in a government in exile in the US, he was allowed to continue on until the US was to be the US would liberate the Philippines. But he died, and then was taken over by take over si Osmeña. That was a term extension. Another term extension was, of course, martial law. Matatapos dapat ang term ni Marcos Sr., but because of martial law and the change in the Constitution, nag-extend yung term niya without even going through an election. Actually, when people are afraid of term extensions, it's not a term extension that they're afraid of. It's the lifting of term limits or changing term limits. But actually, we shouldn't even be afraid of that. Kasi actually, mas nakakasama yung ginawa nating term limits. It's according to a study by Professor Pablo Querubin of New York University, it's the term limits that actually exacerbated the dynasty problem in the Philippines. Because of the term limits, hindi na pwedeng mag-run yung isang mayor na gustong-gusto ng mga tao niya, and he has a lot of projects that he has to continue. He lets his wife or one of his kids take his place. Ayan, dynasty. According to Yuko Kasuya, there was also there's a book that she wrote which shows that our party system fragmented as a result of the removal of the ability of the president to run for re-election. So, question, bakit ba tayo takot na takot sa pagtatanggal ng term limits when in fact, the term limits made things worse? Our system is not actually a US system. It's more like the Mexico system. You look at their term for president, 6 years, single term. Senate, two terms, 12 years in total, 6 years each. Very similar. House of Representatives, yung lower house, 2 terms, 3 years each. Very similar to ours. Ours is 3. But we're like Mexico. Okay? My point is, bakit tayo takot? Bakit tayo takot sa re-election? Unlimited. We're like Latin America, actually. Like the rest of Latin America. Yun lang. Bakit tayo takot?
Okay, turns out not to be a very quick question after all. Justice? What? Professor Tony?
Okay, I just wanted to address that issue of term limits. No, I think it reflects a fear that, again, it's a trauma from the martial law period that people or leaders can perpetuate themselves. This is the way they do it. But again, if I think about this, if it were a parliamentary system which provides transparency in budget allocation or expenditure, and not just the parliament, the national parliament, but even in local governments, no? If it were parliamentary systems with the kind of transparency there is in the spending, I think there will be a disincentive, or at least it will lessen the incentive to perpetuate yourself in power, because it's really an economic strategy for families. No, it's a very lucrative position to be in, whether whether it's mayor or congressman or senator. No? There's so much of our public funds are out there, and that's really all it is about. No? Now, in other countries, there are no term limits, but leaders are on their toes because they're subject to transparency. They have to account, for how they spend or how they are going to spend, and that's, I think, what happens. It renders the question of term limits moot, and also addresses that, like with President Ramos, the issue was how come 6 years is too long for a bad president and too short for a good president. No? But in parliamentary systems, you can have a party in power that represents the policy that will push, again, to our dream of poverty eradication and so on and so forth. So it's, again, I think my friend Orion's just trying to point out, it's nothing to fear. No? And in any case, it's something that we can discuss. That's why if it's a constitutional convention, then it's subject to debate, subject to discussion. But to absolutely refuse to talk about it, I think is also dishonest. No? I think it's something that you should take away with you today. No? Now, young people, please, review, study, and then let's look at all of these items, all of these possibilities, on improving the system and upgrading our operating system. Okay, thank you.
Thank you very much, Professor Tony and Justice Carpio. So that's about all the time we have for today. Thank you very much for attending this morning's debate. And we'd like to thank the Ateneo Law and Liberty Circle and Attorney Lawrence Arroyo for organizing this forum. Maraming salamat po. Magandang umaga at magandang hapon po sa ating lahat.